In July 2019, Jeffrey Epstein was arrested again. Federal prosecutors announced serious charges. For many people, it looked like justice was finally catching up. But that moment raised an uncomfortable question. If the evidence was strong in 2019, why had something similar already surfaced more than a decade earlier? Because in 2008, there had already been a federal investigation. There had already been witnesses. There had already been documents. And yet, instead of a federal trial, there was a deal. A deal that allowed Epstein to avoid federal prison. And years later, one question still lingers. How was that deal approved? Long before the headlines of 2019, Jeffrey Epstein had already built a carefully crafted public image. He described himself as a financier, someone who managed wealth for powerful individuals. He moved comfortably in elite social circles, attending private gatherings, funding academic programs, and appearing alongside politicians, scientists, and business leaders. To the outside world, he projected influence. But in the early 2000s, a very different story began to surface in Florida. Local law enforcement started receiving reports involving underage girls. The allegations were serious. Multiple young women described similar patterns of behavior. What began as isolated complaints gradually formed a larger picture. By 2005, the Palm Beach Police Department had opened a formal investigation. Detectives gathered statements. They interviewed witnesses. They executed search warrants at Epstein's residence. Evidence was collected. Electronic devices were examined. Financial records were reviewed. As the case expanded, the potential scale of the allegations became harder to ignore. In 2006, the case was referred to federal authorities. Prosecutors began reviewing whether federal charges could be filed. At that stage, the discussion involved serious counts that could have carried significant prison time. From the outside, it appeared that the system was moving forward. There were victims willing to testify. There was documented evidence. And there was growing pressure to pursue the case aggressively. Yet, behind the scenes, conversations were taking place that would dramatically change the direction of the investigation. Negotiations began between Epstein's legal team and federal prosecutors. These were not public discussions. They were not widely reported at the time. But they would result in a non-prosecution agreement that later became one of the most controversial legal decisions connected to the case. Instead of facing a federal trial, Epstein entered a plea agreement in state court in 2008. The terms of that agreement would later spark outrage. Because what many expected to be a high-profile federal prosecution quietly transformed into something far more limited. And at the center of that transformation was a deal negotiated out of public view. A deal that would shape everything that followed. Years later, when Epstein was arrested again in 2019, many people were surprised. But others were not. Because for those who had followed the earlier case, the real question was not why he was arrested in 2019. The real question was why the federal case in 2008 had never fully moved forward in the first place. In 2008, instead of moving forward with federal charges, prosecutors entered into what was known as a non-prosecution agreement. At first glance, that phrase sounds technical. But its impact was significant. Under this agreement, federal prosecutors agreed not to pursue federal charges against Epstein, provided that he pleaded guilty to state-level offenses in Florida. The difference between federal and state charges mattered. Federal charges could have exposed Epstein to a far longer sentence. The state plea deal resulted in a conviction for 2 state offenses. He was sentenced to 18 months. On paper, that number may sound substantial. In practice, the conditions of his confinement became one of the most discussed elements of the case. Epstein was housed in a county jail. But he was granted what was known as a work release. 6 days a week, he was permitted to leave the facility for extended hours, reportedly spending much of the day outside the jail under supervision. He returned at night. For many observers, this arrangement appeared highly unusual given the nature of the charges. Another detail drew attention years later. The non-prosecution agreement did not only apply to Epstein. It also included broad language that extended protection to potential unnamed co-conspirators. That clause would later become one of the most controversial parts of the agreement. At the time, however, the deal was not widely publicized. One of the most significant criticisms that emerged later involved the victims. Under federal law, victims are generally entitled to be informed about significant developments in a case. Years later, it was revealed that many victims were not informed in advance about the non-prosecution agreement. Court filings would later show internal communications discussing the handling of those notifications. When those documents became public, they intensified the debate. Because the core question shifted from the conduct itself to the process. Why was a federal case, reportedly supported by substantial evidence, resolved through a state plea agreement? Why were the negotiations conducted largely out of public view? And why did the agreement include protections that extended beyond a single defendant? Supporters of the prosecutors involved have argued that legal cases often involve compromise, and that securing a conviction even at the state level ensured accountability. Critics have countered that the outcome appeared disproportionate to the scope of the allegations described in investigative reports. The controversy surrounding the deal did not explode immediately. It grew slowly. Investigative journalists revisited the case years later. Court documents were re-examined. Internal communications were scrutinized. And gradually, the 2008 agreement became a focal point of renewed public attention. By the time Epstein was arrested again in 2019, the earlier deal was no longer a footnote. It was central to the narrative. Because the arrest raised a broader issue. If federal authorities believed in 2019 that serious charges were warranted, what had changed since 2008? Was it new evidence? A different legal strategy? Or a reassessment of a decision that had already drawn criticism? The non-prosecution agreement, once quietly filed and largely unnoticed, had become one of the most debated legal arrangements in recent memory. Not because it was illegal, but because many questioned whether it reflected equal treatment under the law. And that question more than any headline is what continues to define the 2008 deal. At the time the non-prosecution agreement was finalized, the U.S. attorney overseeing the case in the Southern District of Florida was Alexander Acosta. As the chief federal prosecutor in that district, his office held ultimate authority over whether federal charges would move forward. For years, the details of the 2008 agreement remained relatively obscure outside legal circles. But that began to change. Investigative journalists revisited the case. Court documents were examined more closely. And questions resurfaced about how the agreement had been structured and approved. One of the central issues was transparency. Internal communications later revealed that discussions about the plea deal had taken place over an extended period. At the same time, many of the victims were not informed in advance that the federal investigation would not proceed. Under the Crime Victims Rights Act, victims are generally entitled to certain notifications and participation rights in federal proceedings. When this aspect of the case became public, it intensified scrutiny. Civil litigation followed. Attorneys representing victims argued that the non-prosecution agreement had violated federal law by failing to properly inform those affected. Years later, a federal judge would rule that prosecutors had indeed violated the Crime Victims Rights Act by not notifying victims before finalizing the agreement. However, the ruling came long after the original plea deal had been executed. By then, the legal landscape had shifted. the agreement itself remained in place. Meanwhile, public debate expanded beyond the courtroom. Some legal experts defended the decision, suggesting that plea negotiations are often complex and influenced by evidentiary challenges. Others questioned whether the resolution reflected equal treatment under the law. The controversy followed Alexander Acosta for years. In 2017, he was nominated to serve as U.S. Secretary of Labor. During his confirmation process, questions about the 2008 deal resurfaced. Acosta stated publicly that the agreement had been reached to secure some measure of accountability, arguing that the alternative at the time may have resulted in no conviction at all. He maintained that the decision was based on prosecutorial judgment and the legal realities of the case. Critics remained unconvinced. When Epstein was arrested again in 2019 on federal charges in New York, attention returned to the earlier agreement. Under renewed scrutiny, Acosta held a press conference defending the decision made by his office more than a decade earlier. He described the plea deal as a product of its time, emphasizing that the legal standards and available evidence then were different from those in 2019. But the public response was divided. Within days of Epstein's 2019 arrest, the earlier non-prosecution agreement was once again at the center of national debate. Not because it was new, but because it now stood in contrast to the aggressive federal prosecution that had finally taken place. The question many observers asked was not simply whether the deal had been legal. It was whether it had been proportional. And whether similar defendants, without wealth or connections, would have received comparable treatment. That debate did not produce a single answer. But it transformed the 2008 agreement from a quiet legal resolution into a defining chapter of the Epstein story. A chapter that continues to shape how the case is understood today. To understand why the 2008 agreement continues to generate debate, it helps to look beyond a single case. Plea agreements are not unusual in the United States. In fact, they are the norm. The vast majority of criminal cases federal and state are resolved through negotiated pleas rather than full trials. Prosecutors often argue that plea deals conserve resources, reduce uncertainty, and guarantee at least some level of accountability. Trials are expensive. They carry risk. Even strong cases can fail before a jury. From a legal standpoint, negotiation is part of the system. But the system also depends on consistency. When similar crimes produce drastically different outcomes, public trust begins to erode. And that is where the Epstein agreement stands out. It was not simply that a plea deal occurred. It was the structure of the agreement. The decision to avoid federal prosecution. The inclusion of broad protections for potential co-conspirators. The conditions of confinement. And the manner in which the agreement was handled. Each element, taken alone, may have had legal explanation. Together, they created an appearance that many observers found difficult to reconcile with standard practice. Legal scholars later debated whether the agreement reflected prosecutorial discretion at its broadest limits. Some defended it as a strategic compromise within a challenging case. Others viewed it as an example of unequal application of justice. That broader debate extends beyond one defendant. It touches on questions that surface repeatedly in high-profile cases. How much discretion should prosecutors have? At what point does negotiation undermine accountability? And how should transparency be handled when victims are involved? The Epstein agreement became a reference point in those discussions. Not because plea deals are rare, but because this one became symbolic. Symbolic of perceived imbalance. Symbolic of power intersecting with process. And symbolic of how public confidence can be shaken when legal outcomes appear disconnected from the severity of allegations. By the time the case returned to national attention in 2019, the 2008 agreement was no longer just a legal document. It had become part of a larger conversation about fairness, discretion, and accountability within the justice system itself. And that conversation did not end with Epstein. The 2008 agreement did not erase the allegations. It did not close the story. It postponed it. For years, the details remained buried in court filings and legal language. Then, when the case resurfaced in 2019, the earlier deal became impossible to ignore. Some argue that the agreement reflected the legal realities of its time. That prosecutors faced evidentiary challenges. That compromise was the only viable path forward. Others believe it represented something deeper, a system that bends differently depending on who stands before it. The truth is, plea agreements are built into the structure of the American legal system. They are not exceptions. They are standard practice. But the Epstein case forced a different kind of question. Not whether plea deals should exist, but whether every defendant receives the same leverage, the same negotiation power, and the same outcome. When wealth, influence, and access to elite legal teams enter the equation, does the balance shift? Or does the system function the same way it would for anyone else? That debate did not end in 2008. It did not end in 2019. And it did not end in the courtroom. It moved into the public sphere. Into journalism. Into policy discussions. And into the broader conversation about fairness under the law. Because ultimately, the Epstein agreement became more than a legal document. It became a symbol. A symbol of how power and process intersect. A symbol of how trust can be tested. And a symbol of how certain decisions continue to echo long after they are signed. So the question remains: was the 2008 deal simply an aggressive example of prosecutorial discretion? Or was it something that exposed a deeper imbalance within the system? The documents exist. The timeline is public. The outcomes are recorded. What people disagree on is not what happened. It is what it means. And that may be the reason the debate has never truly ended.